Good evening. My name is Devin Sullivan. Let me first start off by thanking each and every one of you for taking time out of your busy schedules to join us tonight, including our virtual audience that is watching us as we discuss privacy and artificial intelligence. So thank you. Here at the Ethical Tech Initiative, we feel that we're about to talk about are some pretty hugely important topics: emerging technology concerns around artificial intelligence, algorithmic decision-making, and privacy interests. If you haven't already, we hope that you'll grab a bite. There's Thai food in the back and some drinks after our discussion. Perhaps Joe and Garrett are also members of the ETI, and they will be serving drinks, or at least have a bottle opener. So thank you so much. The Ethical Tech Initiative of DC at the George Washington University is an interdisciplinary collaboration that works to advance values of fairness, content integrity, privacy, due process, and transparency within widely deployed technologies, and to develop technological solutions to provide access to justice in the context of civil actions and educational resources to marginalized and underrepresented communities, including incarcerated persons and other self-represented litigants. We are thrilled to introduce you to our incredible panelists, who individually and together bring a breadth of experience and expertise about artificial intelligence, privacy, and emerging concerns over both. First, we have Ben Winters from the Electronic Privacy Information Center, also known as EPIC. He is counsel at EPIC and leads EPIC's AI and Human Rights Project. His work focuses on AI and automated decision-making applications that disproportionately affect marginalized communities, such as surrounding the criminal legal cycle. He is a graduate of the Benjamin Cardozo School of Law, where he was editor-in-chief of the Cardozo Journal of Equal Rights and Social Justice, and the president of the Data Law Society. We also have Calli Schroeder. She is the Global Privacy Counsel at EPIC. Calli focuses on international privacy developments and fosters relationships between global privacy experts and EPIC. She previously acted as a Western Research Fellow for the International Association of Privacy Professionals, interned with FTC Commissioner Julie Brill, and later performed international privacy compliance and security work for clients. Calli is a 2016 graduate of the University of Colorado Law School, where she serves as the lead student note editor for the Colorado Technology Law Journal and acted as a student attorney for the Samuelson Glusco Technology Law and Privacy Clinic. Then we have Christine Bannan. She is policy counsel at New America's Open Technology Institute, focusing on platform accountability and privacy. Prior to joining OTI, she worked as consumer protection counsel at the Electronic Privacy Information Center, where she advocated for stronger privacy regulations before federal agencies and Congress. During the law school, she interned at the Electronic Frontier Foundation, U.S. Copyright Office, and the Wikimedia Foundation. She is an Internet Law and Policy Foundry Fellow and a Certified Information Privacy Professional, and she earned her JD from Notre Dame Law School. Finally, we have Aurélie Mathieu. She currently serves as Assistant Attorney General for Policy and Legislative Affairs at the DC Office of the Attorney General, or the OAG, focusing on issues related to consumer protection, housing, privacy, cannabis, criminal justice, and civil rights. She has worked on policy issues related to algorithmic fairness and privacy and their impact on important life opportunities related to housing, education, and employment. Prior to that role, she served as a real estate trial attorney at OAG. In law school, Aurélie worked on telecom and tech policy issues as a public policy intern for Comcast. She was also a student attorney for the Glusco Samuelson Intellectual Property Law Clinic. She received a JD from American University, Washington College of Law. So I think first we want to just talk to some of the panelists now we know the facts of their careers, about what they actually do and how they got to where they are, and so what interested you about this space, technology and the law in the first place. So I think we will start with Ben.
Hi, yeah, thanks for having me. I think to start with, just growing up and throughout college and law school, I've always been interested in technology, excited about it, kind of just passionate about details around it. And as I just continued to look deeper into it and follow the news and seen things like the ProPublica story, machine bias, that sort of was a sort of landmark story about how pre-trial risk assessment algorithms exist and sort of are a set of spreadsheets that encode a lot of political values into a numerical evaluation, and that's used for a lot of decisions. And from that, I sort of looked into the fact that there are a lot of surveillance and data analysis systems used in a lot of sensitive public contexts, whether that be, public benefits, or again, like throughout the criminal justice whole cycle, not just in the trial, and policing, and the use of gang databases, et cetera, as well as outside of it. And so I should I sort of go to my journey up to now, or stop there and that'll be another question?
We could stop there.
Okay.
And move on to Calli Schroeder, who I think is joining us via Zoom. Calli, can you hear me?
I can hear you.
She's coming out of there.
Can you hear me back though?
I don't think we can hear you, Calli.
There it is.
So we may be having some technical difficulties.
Yeah.
Let's move on to Christine Bannan, and we'll come back to you, Calli. Christine, why don't you tell us a little bit about yourself?
Sure. Yeah, I first became interested in tech policy through the copyright and intellectual property topics. Just in college, was learning about free and open source software and different ways that copyright was like abused to take down content and suppress speech. And so that was really my like entry point into tech policy. And then when I was a 1L, the Snowden revelations happened, and that was really like pivotal to like really grabbing onto privacy as a career option. And when my 1L summer at the Wikimedia Foundation, they were like pursuing litigation against the NSA, and so it was just really exciting. And I thought that I really liked copyright still, but that privacy was really like felt like really exciting and like a new frontier. And I still feel like that this many years later. So
That's fantastic. Aurélie, why don't you tell us a bit about yourself?
Yeah, so my 3L year, I found an internship at Comcast doing public policy. And that's where I got exposed to the technology world. I got to go to New America conference to cover it, just anything technological, artificial intelligence, the future of self-driving cars, because that was still a novel theory. And then what really interested me was the public interest side. I know from a corporation it's hard to see, but figuring out how to like bring internet adoption more in low-income communities, and how those different technologies could affect our future really opened my eyes. So after law school, I started at the AG's office trying to get some litigation experience, but I always knew I was interested in policy. So I went and sought out some policy assignments where I got to dive in more into privacy research, trying to determine whether that's something DC should take part of. And then from that, we dabbled into algorithmic discrimination research, just trying to see anything that protects consumers, district residents. We were always researching it. So my portfolio is very broad, but because technology plays such an important role in people's life now, I pretty much encounter these issues regularly.
Interesting. Calli, speaking of technology suppressing speech, can you hear?
Hello.
Yeah. Okay, fantastic. Why don't you tell us a little bit about yourself?
I got into privacy actually fairly similar to how Christine did. So Snowden revelations came out while I was in law school, and I did some deep dives in that because I just found it really interesting. And then I got into it kind of sideways through copyright classes. I was taking copyright classes because prior to law school, I was a wedding singer a little bit, and I wanted to know how many copyright laws I violated. And my professor for my copyright class was Paul Ohm, who is now at Georgetown. And I just loved his classes, and so kept taking them. And then it was privacy for lawyers and coding for lawyers, and the CFAA and NSA work. And it kind of spiraled from there. And then since then, I've just taken every job I can that keeps me in privacy. It's kind of a never-ending rabbit hole, and I keep finding more things I'm interested in.
Fantastic. Well, I'd love to sort of talk about, what are some of the features working this space that set it apart from other areas of law? Why this space in particular, and how is it different from other fields?
I'll start briefly. I think the thing that excites me most about it, and that I found most interesting, that it's sort of like truly never ending. Another sort of any issue that you can think about, whether it be, as I mentioned before, like public benefits or housing or education or health, like there is a privacy aspect to it. There is an automated decision-making aspect to it. And so it's sort of, you can always find like new applications to it. So it's sort of never ending in that way. And it's also just sort of relatively new. There are a lot of incredible, amazing scholars, and it's just sort of awesome to be able to talk to them and follow their work and try to make the policy as you go along and realize how we can both levy existing protections and what needs to be added on top of that. So just newness of it, I suppose.
Yeah, similar to that, there's a lot of open questions. So there's not a comprehensive privacy law in the US. So working on policy, that's exciting to try to shape that as there are different bills that are introduced and revised and reintroduced. So, slowly making progress towards that, hopefully, in Congress. But, apart from that, even where we do have existing like sectoral laws, it's, or even like GDPR, from the European perspective, it's like, how do those actually apply to the new technologies? There's still a lot of open questions that make it a lot more interesting than I think like in a very established sector of law.
So at the AG's office, I get to come up with policies where I see that there's a need. And then from those policies, sometimes we get to introduce a bill and pass new laws in the district. So because technology in that field is so new, we get to chart our own paths. And we also get to learn from other people who preceded us and also figure out what works best. But also, those issues are ever evolving. You never know what's coming next. You never know what data leak is gonna occur or what people is using AI to identify people on the street and interfere on their privacy. So just not knowing what's next and always dealing with some new issue is what's exciting about this work.
Calli?
Yeah, one of the things that I love the most about privacy is that there are a million directions you can take it, and it really intersects with probably anything you're interested in. Ben obviously specializes in the AI stuff, and he is who I go to when I've got questions on that. I get to work in the international space, so I get to touch a little bit of everything, but also see how new privacy policy and privacy regulations are intersecting with specific regions and specific cultural needs and specific community needs. The emerging tech piece is a huge thing. And one of the things I really love about privacy is that there's a huge range of different ways to get involved in it. So I interned at the Federal Trade Commission, and I got to see a little bit of agency work that way. I worked at the IAPP, and that was a lot of research and writing. I did client work where I was helping people comply with current regulations and kind of anticipate where things were going, and drafted a whole bunch of privacy policies that I would love to pretend people read. But and then now I get to do policy work, and I get to kind of shape the conversations people are having and the direction that talks are going, and look at new and emerging technology. And privacy is such a fun area if you like new things and new challenges, and if you're comfortable with acknowledging that you're never going to be a full expert because it keeps changing on you basically every other day at this point.
Interesting. What do you all think, just sort of for all of you, is it better to pursue an entry point through government work, through private practice? What sort of advice would you have for people who are trying to get into the industry? Do you think that clerking is something that people should do? Is that something that helps with policy?
I think we each have a little bit of a different sort of entry point into the career, so I can speak to mine. Out of law school, I did a project-based fellowship with Equal Justice Works, which is like one of several, including like SCADN and something that I'm remembering, forgetting right now, but where you basically like try to find a host organization that would be willing to host you and specifically design like a 1 or 2 year project that's funded from an outside source to work on researching and reforming a specific area of the law. And that's sort of, I think, unique path into this. It's a lot of those fellowship programs haven't funded a lot of sort of tech-based entry points in the past, but I think they are growing a little bit. And I focus specifically on automated decision-making systems throughout the criminal justice cycle. And so I think that you can get into this work through probably any entry point, and I think clerkships are always like seen as valuable to any employer. But that was my path.
I agree that any entry point is beneficial. With the government, you get thrown in the fire real quick. There's not that hierarchy that you need to evolve through your career, because we're so busy and we always need people to be all hands on deck when it comes to the work that we do. So I got to be in the room with very senior people early on, make my own decisions, make these recommendations directly to my boss instead of having a middle person. So I think in the government, it's given me that leadership and autonomy that I probably would not have gotten if I would have gone to a firm, and it probably would have taken me longer to get into policy. But I don't discredit other paths, because you do get different skill sets that are going to be useful wherever you end up. So
yeah, well, like Ben, I also started with a fellowship at Epic. It wasn't project-based. I just I got some funding from my law school, and then Epic made up the rest to do a year, and then was hired on as counsel after that. And there are a lot of great fellows, like usually 1 or 2 year fellowships at the public interest organizations that are great entry points. I think don't feel like you have to start at a firm if you wanted to do policy, because I mean, if you want to start at a firm, that works, but you definitely don't need that experience to work in policy. I think if you can get a job on the Hill, that's great. Yeah, like any, like she said, like when you're working public service side, you are so just like thrown in and really get experiences that you wouldn't get. And I really valued that. Like my first couple of years as an attorney, I was like the primary drafter on comments to the FTC. And I mean, that's pretty exciting, and getting to be actually, yeah, like have your name on things like when you're fresh out of law school, I think really helps launch your career, and you get to point and say like, I'm the one that actually wrote that, and it's helpful to be able to kind of build that reputation in the field.
I agree with what all of the panelists said. One other thing I would point out is I, like several of the other people, started with a fellowship right out of law school. Not the only way to do things, but it is really helpful if you want to get your name out there and get some publications and do a deep dive into some research. But if you don't do the fellowship route, there are also a lot of avenues where you can self-publish, you can write articles on topics that interest you and submit them. You can still get your name out there in less straightforward ways, or ways that don't necessarily come through your work. I also did a lot of networking on Twitter, which is, I don't know if I'd recommend that for everyone because Twitter's a nightmare, but in some ways really was helpful. And then also it just depends on what works for you in your life. For me, I am calling in from Colorado because that's where I live. And a lot of the jobs that I took were based on kind of what was available according to my geographic restrictions. It really wasn't possible for me to move for large parts of my career. So work within whatever boundaries you have, but there is a way to make a career happen in privacy, regardless of what restrictions you're working with.
That's all really, really good advice. I am curious how each of you wants to see the policy sphere change over time? It's probably a big question for each of you, because you're very passionate about these things. But whether it's artificial intelligence, whether it's privacy, what are the big policy projects that you think are really important?
I think any policy project for me, if it had to be done right, it would have a review process for equity, because we're moving into a world where we have to acknowledge the harms that policies in the past have had on people, especially like algorithms. In 2008, after the recession, it was people found out that algorithms were hindering people from getting back into the job market based on their race and their names, and not having the same traits or characteristics as people as those companies had. Or even with healthcare, a healthy person was probably offered more services than a Black person. Or even when it comes to education, the application process, how that would have been equitable in the past if we would have had a deeper dive into those policy issues and looked into how technologies really play a part in your everyday lives. I think moving forward, any policies that we come, I think it needs to have an equity-centered approach, and that shouldn't be left out.
Very interesting.
I definitely agree with all of that. I think one of the flip sides of the exciting part about this like working in this space is that there's so much that can be done and so much that needs to be done all at once. Like there's the sort of comprehensive baseline privacy legislation that we need in the States, but more specifically to the work I do on AI, I think there needs to be a sort of segmented approach where some certain uses of like biometrics and facial recognition right now just need to be like banned, paused right now, stopped. And it is not something that we need to have out there, and it's causing a lot of harm. It's not necessary. So that's one part. And for all the other sort of uses, I think we don't have to be afraid to put onuses on companies to make sure that they're doing like audits for things like bias and equity, as well as accuracy and reliability and all that stuff, and sort of require significant disclosures and publication of that stuff as just like a sort of baseline. Could go on all day about that, but I think that'll be my contribution for that.
I think there's a lot of work to be done on the intersection between privacy and antitrust. There's if you've been following like the lawsuits against Google and Facebook, especially, a lot of the claims have to do with how they're using personal data, and there's some direct like claims about privacy made, and it's really been an underexplored area in scholarship. So if you're looking for a student note, there's a good topic there for you, I think. But yeah, there's a lot of talk right now about like the end of third-party cookies and like the future of advertising. There's a lot more focus on first-party data because Google and Facebook have a lot of first-party data and other players don't necessarily. So there's both like competition and privacy issues there. And I think sometimes those arguments are made in good faith by the companies and sometimes they're not. So like digging into that more, I think is really important. There's, like Apple and Google especially have been pushing back on critiques on the Hill by saying like, we can't make these changes that would make us more competitive because, or would like improve the access that other competitors have because that's bad for privacy, right? And security. So I think that's something that's been underexplored and is really important right now.
I agree with all of that, but from the perspective I have dealing with international stuff, I really feel like one thing that needs to be considered throughout the whole policy process is making sure that we're paying attention to and adjusting for differences in application in different contexts and different settings. We've already talked about how there are really serious disparities in privacy issues when it comes to people with disabilities, people from different minority groups, different communities. There's a huge disparate impact there already, but on the international level, that applies at a cultural level and in different areas of the world and to different communities within those areas. And so taking all of that into account when you're trying to put a policy in place and being agile enough to adjust when you see that something's not working or it's affecting people badly, I think is a really key takeaway. And it'd be awesome if they could carry that over into new tech and keep that in mind there too. But yeah, I think a little more flexibility and perspective that is not always from straight white people in the US would be really great on a global scale.
Very interesting. On the topic of sort of racial bias and gender bias in artificial intelligence, I'm curious what some of the challenges of bringing lawsuits regarding bias in machine learning are under the Equal Protection Doctrine as it currently stands, and how all you think about sort of advancing these policies, especially considering the 6-3 Supreme Court.
I think there's a lot of different challenges. I think one of them is sort of a lack of, I think the general lack of transparency around the use of automated decision-making systems and the lack of required disclosures around details of it and studies of it that are actually using the data that they're using and publishing the results that the automated decision-making systems are producing, is that there is a sort of lack of concrete data that you can use to analyze and prove discrimination. I think a lot of what we see tends to be something that is definitely able to be studied and confirmed, but often there's not significant rich data sets to prove that it's industry-wide, or that you get one study that was done from one pretrial risk assessment that's used in Florida in 2014, but then you don't actually be able to juggle all of these. And so I think the lack of transparency and documentation and sort of open data sets and all that stuff really contribute, or one small element of what contributes to not being able to enforce consumer protection laws on that.
I agree with Ben.
Yeah, I don't know if I have much to add, but I'll say it can be very difficult, to get access to the information you need to prove some of these claims. So that transparency, just from a researcher perspective, there's if you followed the NYU researchers that were blocked for access to Facebook ad library and things like that could be very helpful into it's hard to craft solutions without better insight into the systems.
Interesting. Calli, do you have anything to add?
Yeah, one quick thing. I completely agree about the transparency aspect, but another thing that I think is a challenge in bringing legal challenges in this area is you have the problem of trying to break down technical issues to a older Supreme Court. And it can be really difficult to do that in a way that stays accessible and doesn't sound like you're talking down to anybody. It's a huge skill being able to break technical issues down into an accessible level for people. But the problem is if you don't do that, then the defense to accusations of bias or accusations of algorithmic issues are going to wade into technical specifics. And once it becomes tech lingo versus tech lingo, judges don't really follow that, and people don't really follow that from a broader educational sense. So I think another serious challenge here is going to be breaking things down in a way that's understandable to most people, which is even harder when we don't actually have access to the information because of transparency stuff. But
that's very good advice from all of you. Very good advice. I'd also be curious. I'm not sure how much of a role artificial intelligence plays in the administrative state right now, whether or not general artificial intelligence that really learns on its own is playing a role in the administrative state, whether it will be able to, whether Congress can delegate to AI. Can you all talk a little bit about the state of where artificial intelligence is and its intersection with administrative law?
Okay, I'm happy to start there, unless you want to.
No, go
okay.
ahead.
I think this state of it right now is definitely not at the like imagination of a general artificial intelligence stuff. I think a lot of what is used in the administrative state, both at the federal and local and state levels, are more akin to sort of like a Excel spreadsheet where inputs are being put in, measured at different sort of weights and factors that are supposed to be able to predict the likelihood of an event. So whether that be that an individual is going to commit unemployment insurance fraud, or the likelihood that a given space in a city is going to be where the next crime is going to be committed. So there are all sorts of applications, and that's used in credit and in hiring and sort of applications. And so what we're really dealing with is like a set of all political decisions put into a sort of numerical output under the guise of like sort of AI or tech. And what it really is making sort of judgments about folks that are acted upon. I think there are like slightly more advanced AI stuff that's used in some contexts, especially in public benefits, where it's like just a mix of the sort of big data broker universe and that connected to sort of like creating a heat list of folks that you think are either going to be committing crimes or committing unemployment insurance fraud or likelihood of having drug overdose, and so you prescribe them less pain meds or whatever. Those sort of functions are just sort of larger because they have larger sets of data going into them. In terms of the like moving towards general artificial intelligence and the extent to which Congress is going to defer to them, I guess all I can say is I really hope they don't. And I don't think that's like something that I'm worried about at this moment. I mean, I'm worried about a little bit of the national security and the military context. We have like just billions and billions and billions of dollars, and all these sort of committees saying, yeah, we should spend billions of dollars on sort of AI warfare and all of that stuff. But I am very happy they don't spend that much time looking into that stuff because it stresses me out. And I hate it. But yeah, I don't know.
No, that's very.
Yeah.
I don't know if you have more, Calli, but
Sorry, going back and forth between the mute button there. No, I absolutely agree with all of that. The only other thing that I'd note is that from our perspective and what we've been working on, it really looks like the actual abilities of AI are being widely outstripped by people deciding that like they're the new tech buzzword and just need to be incorporated into everything, whether or not they actually are helpful or not, whether they're tested or not, whether there's transparency or not. It's in some ways, it's like getting a predictive text algorithm that, suggests how I want to write my email to decide how sentencing needs to go. And there are often people in the loop here that's an AI will spit out a suggestion for an outcome, and then it'll be a human that makes the determination. But there's also been a lot of studies at how susceptible we are to trusting these machines and believing that they're a lot more accurate and a lot more neutral than they actually are. So yeah, the other factor there is that they're just being used administratively in lots and lots of places, and the quality checks are maybe definitely not there in a lot of cases.
And are definitely not required. Like
No,
almost
super
anywhere
not.
except a few places. There are like some pending bills in states that would do that, but pretty much not at all in the US at least.
I think finally from each of you, before we open up to questions, I'd be curious what advice you would give to law students that are interested in getting into the space, and specifically what sort of things that they should be looking out for in terms of fellowships, internships, things that you wish you had done, things that you wish you had not done. Just from each of you, I'd be very curious what you'd have to say.
Sure. I'll say if you have any interest in working on Capitol Hill, get an internship, because that is like, the way to get your foot in the door. It's like an internship is worth like several years of work experience somewhere else. So they just really value that. So I think if you even think you might be interested, try to do one there. And House or Senate side, both equally valuable, I think, to if you can get exposure to a member that's interested in these issues, the committee. Yeah, that's one, I guess, like one regret I have is not doing that. But other than that, I mean, I think looking for, I mean, I could give you practical like job boards and things if you want later, but yeah, there's being open to different sorts of opportunities, things that maybe aren't, because like we've talked about, this touches so many different issues. Like even if your primary responsibility isn't to work on privacy or AI, like that could be a component of your job and could be your way into the field. So just be open to different possibilities, and whether your interest is like litigation, policy, or even like corporate compliance, there's like a lot of different roles that could be good fits.
Yeah, I think one tip that's sort of tangential is, I guess, just sort of know that there are a lot of places to work in this space. Like there aren't as much as a lot of other places. There are not as many public interest orgs or government entities specifically at this as there are law firms or something. But I think like there are certain resources like ILP Foundry, both Christine and I were involved in that, and that's like a place where you can find just sort of like from their job board and from where their fellows have been, you can like realize where you can do this work. I think in law school I was interested in work related to this, but a lot of these are really competitive. B, a lot of them like pay like shit, sorry, excuse my French, and like to what Calli said before, like it's not always something you can do depending on your life circumstances. And so I think what you can do is, especially if you're not able to get one of these jobs or one of these internships throughout, there are places like you can try to write and publish about. You can try to like just follow the sort of tech news and tech policy news. And yeah, similar to Christine, always, feel free to come up after and it could give you some places to follow and whatnot. But yeah, it's sort of meandering advice, but you can do it if you want to, I think is what I'm trying to say.
I agree that the Hill is a good starting point, but like Ben said, it's either unpaid or you're living below poverty. So you really have to make sure that you're well situated and early in your careers when you can make these sacrifices. So I would definitely encourage it. Also look into, local government. We have 13 council offices which you can work in, and you get to charter your own path. You pretty much are the sounding board for these elected officials who are looking for new ideas and way to be more progressive and helpful to their constituents. And algorithms has come up a lot, technology issues come up a lot, but a lot of them don't know how to digest those issues and put those measures into action. So you coming in and being savvy on these issues is gonna be an invaluable asset. And as a elected official staffer, you get to have as much outreach as you want to policymakers, to advocates, to experts, to help you come up with these policy proposals, these bills that you want to draft. You don't always have to draft the bills. You have the advocates do it for you. So having these opportunities to pretty much, you have to do other stuff. Like of course, if you work for the local government, you have to deal with criminal justice, traffic issues, just regular day-to-day problems that people deal with, but they all come in hand, like housing is a big thing now, how people apply for housing, what are those factors that technology plays into that. So definitely stay open, even if you do something you're not interested in the meantime, just to get legal experience or any experience at that. Just keep networking and keep raising your hand, because that's how you get seen. If you're like coming to somebody always volunteering, they're gonna eventually put their foot out for you.
Yep, absolutely agree with what everyone said here. I would say there are a lot of ways to be involved in privacy and to make a name in privacy, even outside of whatever your first job is. If you have the means to do an internship, a fellowship, something like that, that's great. But if that's not on the table for you, there are a lot of other options. There are, like I mentioned, I was at the IAPP for a while. They take article submissions from everyone. So if you're really interested in a privacy topic and you've been doing some work on that, write up a draft article and just contact their publications department, listed on their website. And you can say, hey, I've been writing about this topic. Do you guys have any interest in publishing it? And a lot of times they'll work with you on that. So you can at least get your name out there a bit. They also do certifications, which can be a really helpful thing depending on where you're going in privacy. I know they were helpful for me. I also know that they can be expensive. So keep that in mind. But you can find opportunities in a lot of different places to be involved in privacy work. I didn't get to start and stay in policy because of my geographic stuff. I had to come back, and I worked in a law firm doing privacy and intellectual property and picking up work with like contracts and wills and trusts and whatever would get my billables up. But if it's something that you're really passionate about and there's something you really care about here, there are always ways to find more people that are interested with you and let them know that you're interested in things. Again, Twitter was really helpful for me with that. Of my last 5 jobs, 4 of them came directly from connections I had made on Twitter. So the amount of expertise and the generosity of time people have there to engage with these issues, really shocking. There are people that are just light years above where I am professionally that were willing to engage with me and have conversations. And sometimes those opportunities are just the kind of informal ways you have to go about a career.
I second that. My 1L internship I found through messaging with someone on Twitter after not being able to find someone's contact info. And so definitely, I don't know, get creative and don't worry about like trying to reach out to folks. Whether that be all 4 of us, I'm sure I think we're all on the same page that we're down to be able to reach out to, but also just people are willing to help you when you ask usually, not across the board. There's a lot of luck and privilege and all that stuff baked into that, but it's worth trying sometimes.
Well, thank you all very much. We're going to open up to questions, but how about a round of applause so far? We also have beer and wine in the back, sodas. There's Thai food. If all of your questions have been answered, feel free. But otherwise, I think we're going to open it up. So, does anyone have any questions?
Yeah.
Joe?
Oh, I guess I'll start. First of all, thank you guys all so much. I have a question. Kind of 2 questions, and I think they're related to one another. This summer, I got a committee to sort of examine how the COVID pandemic affected litigants in the court system, because of that they were forced to virtually in a lot of states, if not every state, because of that simply no alternative. And as a result of that examination, I started to notice, really from our government side, from our judiciary side, there is no disclosure of information about what you were consenting to when you went here for a virtual court hearing. And I guess because you guys talk a lot about transparency, so I guess maybe this is a bit of an overhead question. Is there some standard of transparency that you all have to see that we're not getting? Because I was dramatically on that. Because, for example, you use Microsoft Teams, and in Microsoft Teams terms of service is a thing that says, oh, we can reproduce any content that you host on this and give us a license to use your content. I think it was but there's no disclosure about that at all on any of the court websites that you're now forced to use because you're virtually. So I guess the first question is there a metric or some gold standard of transparency that you would like to see them currently definition of that?
Having litigated, I don't think there's any lack of transparency pre-pandemic in the courtroom. Everything is always public. Discovery, you might have some stipulations. I think those still apply in the virtual world. So even before, I guess, Zoom and stuff, the courtroom had to be open. Any judge would shut down any attempt to close down a courtroom. You can go access any filings online. So it just makes it more accessible and increases the reach. But I think it's up to the attorneys to advocate for their clients to make sure that documents and information that may be harmful to them does not go out there on the internet and harm their clients. And I think judges would be receptive to that. So it's up to the attorney to protect whoever they're representing.
I think that this is, that's something that goes back to the fact that we don't have a sort of, like in addition, obviously, I totally agree with everything you're saying, but goes back to the fact that we don't have a sort of baseline privacy law that requires teams to have a sort of robust, clear disclosure about how they're going to be handling your data and, how they might be giving it to third parties, how, anything like that. And it just shows the sort of like reliance on third-party contractors and on the sort of commercial industry and deferring to their standards. And so when we don't have sort of strict protective rules and laws about that on a federal sort of minimum, you get issues like that. And so like on one court, and you might have to do Zoom, which has different disclosures and privacy policies, and one Teams and all that stuff. So I don't have a direct answer in terms of like what the specific standard or gold standard is, but it's like illustrative of the issue that we don't have those sort of baseline rules or protections.
Yeah. And yes, unless anybody else has, I do have a second related question. So the other issue is, especially in terms of sort of what you agree to, as we live in a more virtual world and we're agreeing more and more to terms of service, new applications each day that require some use of your data. Do you think that's, and again, it's a very big normative question, eroding the chance of having any sort of sense of privacy, or does that come in with the need for us to implement the base level of protection? Because I'm wearing a tracker on my arm right now. I assume a lot of people are. Do these types of tracks, I love this, and I'm happy to sacrifice any inconvenience that comes with it. But does that have a mindset that I'm willing to take the sort of give up some sort of security or privacy to that incense for efficiency? That mindset really hurt the work that all of you do in trying to ensure a privacy right for everyone?
Well, I'll say, I think that that kind of thinking like really plays into the tech giants like hands. And I really push back on the narrative that like, if you don't like something, you should just not use it. Like it is important to make choices. Like I don't use Amazon, like I don't do certain things that because, to align with my values, right? And I think that's good to do that, but to put all of the onus on the user is really misplaced. And I think it just reinforces like just reinforces like the power that the companies have, and it allows them to defer responsibility. So I think you should use like what you want to use and be as informed as you can, and like demand better treatment. And I don't think those things need to be inconsistent with one another.
Anyone else? Calli, I have a question for you, and then I'd also be curious what anyone else has to say about it. But I know that recently the Senate passed the Secure Equipment Act that says that the FCC should no longer review applications from companies that are ruled a threat. So this means Huawei, ZTE, 3 other Chinese companies cannot be used in US telecom networks. We're seeing the issues of privacy sort of become an inflection point in what many are saying might be, this is a bit of a provocative term, but might be some sort of second Cold War between the US and China, some sort of great power tiff is clearly going on. Can you guys, and Calli especially, because I know you're doing international work, how that conflict is creating opportunities for better privacy protections, and how it's also maybe going to endanger our privacy protections?
Yeah, so the whole dynamic between China and the US, and frankly, China and most of the Northern Hemisphere, has been really fascinating to watch and be part of, partly because the dynamics of it really both bring privacy to the forefront because people are using that as a touch point, but also serve a little bit as kind of a shaming mechanism for the US. Like, there's a lot of criticisms of what China's doing and how they're operating. Obviously, the SEC actions are a big deal. But China always has the rejoinder that they actually have a national privacy law and we don't. So that keeps coming up. At some point, you think that would kind of, just the embarrassment would motivate people to pass a law, but we'll see. But yeah, the international dynamics of that are really fascinating. I do feel that China is used a little bit as kind of a global scapegoat, where people pick a lot on what China's doing. And China does do a lot of incredibly privacy invasive and human rights violating actions. But so does the rest of the world, including many of the countries that are trying to kind of embarrass them as much as possible. So I really hope this gets used as an impetus for other countries to identify their own shortcomings and work towards better global privacy. You know, this could be a situation where other countries trying to pressure China into passing better or more meaningful privacy regulations or stop privacy harmful practices will boomerang back around and prompt them to reevaluate some of their own practices. So it could lead to a more global rise in privacy protections. Unfortunately, there's also a little bit of a risk that the constant battle of, well, you're yelling at us about this, but you do X, Y, Z, is just going to devolve into this battle of everyone pointing out the other people's weaknesses and everyone kind of giving up and saying, well, I guess we all suck at it and we're just going to keep being terrible at this. I really hope that's not the direction things go, but I'm hopeful this ends up being a motivation for everyone to do better when it comes to privacy.
As someone more US focused, but watching in the AI space, that the federal government sort of advisory bodies and also Congress are using the fear of the sort of nebulous China doing bad things with AI as an excuse for like, no, we have to heavily invest in deploying AI all over the US because, and like, since it's in the US, it's just magically democratic and good, which is just like not true, obviously, if you can't hear by the tone of my voice, but I think that it's like a very dangerous narrative to use to exploit like the billions of dollars of just like, we're doing it better, and if we have more, that's maybe one iota less bad or the same, somehow it's better. It's sort of like this exploitation of the narrative, because like we can innovate, but we can innovate in a way that protects people, and like have better laws about it, and that's the way that we can be innovating. I think that like this goes back to Christine's answer to your other question. Like, it is not like we can put the onus on companies. They're not just going to all shut down and we're going to be Luddites within 5 minutes. Like, they'll figure it out. They'll work within rules that actually protect people. And I think the excuse of like Russia and China existing and being evil or whatever should not allow that narrative to like take over our sort of federal approach to AI policy, which I think we are as like a country, not us. But yeah.
That's both very good answers. Thank you so much. Does anyone else have any questions? No? Okay. Again, I thank you all so much for joining us here tonight. And I'm going to clap for you. I'm going to try to get a slow clap going. Thank you all very much. And we hope to see you at the next event. I think on Wednesday. At what time? At 12:30. We're going to have an event about Twitter and birdwatch and counter speech online and regulations of content. So we hope you'll join us for that as well. And yeah, thank you all for being here. Really appreciate it.
Thank you.